Hey there, James Harrington from Polito Harrington. I want to talk a little bit about health insurance and health insurance liens today. As your case starts to hopefully move toward settlement and resolution, one thing to be aware of is that some health insurances, when they pay for medical treatment that was a consequence of an accident, and then you recover money from a third party or their insurance company for that accident and medical treatment, some health insurances have a right to be reimbursed out of the settlement. And so you should be aware of that. And whether or not your health insurance does have a right to be reimbursed will actually be dependent on the type of health insurance that you have. So there are effectively three types of health insurance. There's federal health insurance, which is Medicare, and then also if you're a service member, that insurance through TRICARE or programs like that. There's state health insurance, which is typically Medicaid. Here in Connecticut, it's commonly referred to as Husky. And then there's private health insurance. Federal Medicaid almost always has a right to be reimbursed out of a settlement. Same thing goes with military-based health plans. State health insurance also has a right, but it's not quite as absolute. Basically, the way it works with Medicaid is that if the state, in this case I'm talking about Connecticut, if the state puts us on notice of a lien, then we have a requirement to pay that lien back. In most instances, though, if they don't send us that lien and the case settles before they do that, then we don't have to pay them back. And then, of course, you have private health insurance. Private health insurance is the more complicated of the three. As a general rule, in Connecticut, private health insurances do not have a right to be reimbursed out of a settlement with a third party. However, there is an exception. If your health insurance falls under a federal statute called ERISA, then they do have a right to be reimbursed. And basically the way that ERISA works in this context is what you typically see is you have a very large employer who has decided that it's more cost effective to pay for the medical treatment that their employees incur out of their own assets as opposed to paying a health insurance premium for all of their employers. Now that is employees, excuse me. Now that doesn't mean that, well, if you say to yourself, well, I have health insurance through my job through a private health insurance company, that must mean it's not ERISA. That's not quite the case, because even companies that have ERISA plans still will have an insurance carrier in place. So you may think you have Blue Cross Blue Shield, but in fact your employer and Blue Cross Blue Shield have made an agreement that your employer is actually going to pay out of its own assets for a certain amount of your medical treatment, kind of up to a limit. It's kind of like a deductible plan for your employer. And they say as long as, this employee's medical treatment doesn't exceed X amount of money, we're going to pay for it dollar for dollar. And then if it goes over that amount, then we're going to ask for the health insurance to step in and pay for the rest. That allows your employer to actually keep the premium expense down. So if you have an employer who's under ERISA, then they do have a right to be reimbursed if we go to settle a case. The good thing to know is that in all three of these situations, health insurances do not pay what is actually billed. So when you go to the doctor, you get a certain bill, say for $10. Health insurance is only going to pay $4, $5, $6 out of that $10. So they're not getting dollar for dollar reimbursement out of your settlement. They'll get a fraction of that amount. But if you have any questions specific about health insurance liens on your particular case, you should reach out to your team and we can give you a better sense of how the landscape looks on your case.